So, I'd like to recognize, we'll hear your comments afterwards, ano? Bigyan ko lang ng floor kay Senator Honasan. Thank you.
Thank you, Mr. Chairman. Secretary Aguirre.
Senator.
Good morning po. Please educate us on the issue I want to raise, taking off from the issue raised by our chairman. Ano ho ba ang quantum of evidence required para payagan ng korte yung wiretapping? Dahil linagay ho namin sa bill namin, no? I'm referring to proposed Senate Bill 21 and 48. Is it going to be mere suspicion or probable cause? Sa bill ho namin, linagay namin probable cause. Pero let me explain, give me a little time to explain. No? Mabuti ho si Senator Lacson at saka si Senator Soto, may ground time sa anti-drug operations. No? One lifetime ago, when we were assigned to the Ministry of National Defense, we went against drug traffickers also. Hindi pa huuso nun yung shabu. So, heroin, cocaine. Can you imagine ho ang feeling ko no? Army officer. I did not even know what cocaine or heroin looked like. But I raised this issue because this might be material to our operators on the ground. Panahon ho namin to, it's about 30, 40 years ago. We're operating under a window. Huhulihin mo talaga yung conversation in that window. Of course, iba ho ang sitwasyon, no? We are under different circumstances. So, pag hindi ka nakapasok dun sa window, wala na. Because orders, instructions from the heads of the drug syndicates would be translated into action on the ground. Sa panho ito, no? Sa mga sindikato. Kami naman ho, we operated under the... We tried to wiretap. Of course, we operated under the instructions of the Minister of National Defense. And ho, we need to strike a balance between... Right. So, tinatanong ko lamang po yun because I'm looking at this from the perspective of our operators. Where kailangan mahuli nila yung conversation within a window. Would this determination as a basis for a court order be material to that time variable? Would it matter if mere suspicion or importante yung probable cause para mahuli talaga natin yung conversation?
May I first go on the quantum of evidence necessary in some other cases?
Opo.
We know that in cases of in criminal conviction, it is proof beyond reasonable doubt. In civil cases, then preponderance of evidence only. Sino mas maraming or mas matindi ang ebidensya, then he will be the one to win in civil cases. Then in administrative cases, we have substantial evidence in order that the respondent in administrative cases would be given a penalty as called for by the law. In your case, I believe that it is mere existence of probable cause. And probable cause defined as such facts and circumstances that would lead a reasonable prudent man to believe that a crime has been committed and that the accused or person in custody of the law is guilty and there should be a case should be filed against him. This is in connection with the investigation, preliminary investigation of criminal cases before our prosecutors, before the Department of Justice and our Fiscal's Office. Now, in connection with this Wire Tapping Act, we believe that the probable cause should be present before the judge or a court would allow the wiretapping or would issue the order to wiretap a certain conversation. In the United States, under Code 2518, which is the procedure for interception of oral, wire, or electronic communications, it is provided that 3. Upon such application, the judge may enter an ex parte order as requested or as modified authorizing or approving interception of wire, oral, or oral electronic communications within the territorial jurisdiction of the court in which the judge is sitting. And outside that jurisdiction, a mobile interception device authorized by a federal court may be allowed. So it is the judge that determines on the basis of the facts submitted by the applicant whether a probable cause is present. So we believe that the wordings of the bill is correct, that it is only the quantum evidence as called for under the definition of probable cause.
Thank you, Secretary. Mr. Chairman, with your permission, one last comment. No? I just want to relate this ngayon, Secretary, no? Gentlemen, to the political window that is given to our police, to the NBI, even to the armed forces, who will, I understand, be involved in this. No? After it has been declared as a total war and practically a national security problem. Alam nyo, Secretary, I don't know when this political window will happen again in our lifetime. Actually, we raised this in another committee hearing. No? Inggit na inggit ho kami ni Senator Lacson kina General De La Rosa. Because the political leadership, I said, you do your job. Just don't give me any BS. No? You tell me the truth. No? You do your job, I will give the orders. And I will assume responsibility for the orders that I give you. That's why I ask Director General De La Rosa, may inutos ba sa inyong illegal or constitutional or yung, alam mo ho, yung to an operator, 1 second of hesitation is life and death. Pag medyo nag-hesitate ka o may duda ka dun sa sanity or the morality or the legality of the order, patay ho kayo. Senator Lacson and I, when we were in the armed forces, operated under that advantage. When we are given an order, alam nyo, Secretary, it was almost linear. Yun ang mission, yun ang kalaban. Diretso, we never looked back. Ngayon ho, we have that window. And I'm happy that General De La Rosa, no? I'm not doing this to, hindi naman ako nagpapalakas kay Bato, no? I'm happy that they recognize the fact that their job is to implement policy, not to explain policy. That is the job of the political leadership, the one giving the order. And categorically, the political leadership has said that he is, or the executive is assuming full responsibility for all these orders. I just put that on the table para we can reconcile what is required if we pass these laws, no? At operational level, and the consistency that is required at political level. Salamat po, Secretary. Thank you, Mr. Chairman.
May I have a comment, Mr. Senator? I believe I agree with you, and we have to take this opportunity that presents to us only at this very moment. So, as we say in the military, obey first, ask question later.
Salamat po.
Senator Soto is recognized.
Yes,
After
just one-
Senator Soto,
to wrap-
Senator Delima.
Just to wrap up my issues with the Department of Justice. So, after receiving these statistics, so in the last 5 years, 3,482 convictions out of 126,000. How many cases were reviewed? How many dismissed drug cases were reviewed by the Office of the President through the DOJ Secretary?
Of the total, this is with respect to DOJ only, Mr. Senator. Of the total cases received from 2010 to 2016 as of July 31, we have received a total of 3,081 cases. The pending
81 cases.
automatic review is 1,581. The automatic review resolved is 1,469, and those pending with the motion for reconsideration with the Prosecutor General is 22, and the MR on the AA resolve or automatic resolve is 9. So,
Ano ho nangyari doon sa 1,469?
yun po ang question natin eh. Na hindi natin alam dito, sa statistics na ito, whether those cases have been dismissed favorably or against the government.
Yeah, that's
Wala
what I
pong
wanted
picture
to know.
tayo
So,
dun eh.
can your undersecretaries find out for us so that we can submit to the committee?
Yes, Your
Ano
Honor.
nangyari dito sa 1,469 na ni-review?
Yes, Mr. Senator, we will submit the breakdown of the cases, how they were resolved.
All right, thank you very much.
Thank you, Your Honor.
Before I recognize Senator Delima, bago lang iwanan yung wiretapping issue, yung PDEA has, ang position nyo is mere suspicion, hindi ba? And I see your point because pagka probable cause nga naman, arestuhin na nila. They don't need a court order because once they have established probable cause, they'll just arrest the perpetrators or the offenders. Kaya ang position lies a mere suspicion, pwede nang gawing basis to apply for a court order to wiretap communications. So, what's your comment, Secretary?
Mr. Senator, yung po kasing sinasabi ng probable cause, it is the amount of evidence to be submitted to the judge. In other words, this is not addressed to the law enforcement officers. Kukuha pa lang tayo ng the order to allow the wiretapping.
I would like to comment.
Yes, Your Honor. We recommended that the amendment of the anti-wiretapping law to the level of the exemption given to terrorism and the anti-kidnapping for anti-kidnapping cases, Your Honor. This will make the operation against drugs, against illegal drugs, to be more easier, Your Honor.
Well, instead of suspicion, maybe we can use the term reasonable ground to believe, no? And that's below the level of probable cause. Kasi for probable cause, we're talking of filing of information in court. Kailangan ma-appreciate. Kaya nga meron pang judicial determination of probable cause pagdating sa level ng korte. Pero yung reasonable ground to believe, ito yung old sa rules of court. Di ba yung dating law enforcement officer may arrest on the basis of reasonable ground. Naalis na yun eh. Inaiba na yun kasi in his presence, has just been committed, about to be committed, nawala na yung reasonable ground to believe. But at least, when a law enforcement agent wants to secure a court order to wiretap communication, baka pwedeng gamitin na lang yung reasonable ground because we're crafting a law for the guidance of the judge who will issue the court order. Ako I'm in agreement doon sa proposal na ibaba na sa RTC. Kasi kung Court of Appeals, naisip ko lang kasi when I crafted the bill, sinunod namin sa Human Security Act or sa money laundering na kailangan Court of Appeals. But it's going to be a more difficult task to approach Court of Appeals divisions for that matter, no?
Opo, the problem there is that if we limit it to the RTCs, it will have limited territorial jurisdiction. So if the persons to be tapped, especially under our laws, which requires the, if there is consent, the required of both parties, one may be outside the jurisdiction of the RTC, then perhaps we could create a special RTCs which will have jurisdiction over the whole Philippines, just like the issuance of not necessarily special. We just empower some RTCs, just like in search warrants, where QC, the RTCs of Manila and Quezon City could issue search warrants that would be effective even outside the National Capital Region.
Yung ex parte is a no-brainer, ano? Kasi Pagka naman nag-hearing pa yan bago ma-issue yung court order, hindi na magsasalita sa telepono yung kausap mo. So it's a no-brainer. Wala tayong issue doon. Ang issue lang dito, ano yung level ng, anong ground ang kailangan natin for the judge to be authorized under the law or under the amendment to issue a court order. Is it mere suspicion, reasonable ground to believe, probable cause, or kung anumang level?
We will have no objection, serious objection, if it will be lowered to mere suspicion or between probable cause and but above suspicion. So sa gitna.
Above suspicion and lower than
Lower than
probable
probable
cause.
cause.
Okay lang, Secretary. Thank you. Same point.
That's actually the same point I'm raising, although I still have questions really on that
Good morning,
point
Senator.
and another point. But I can
Mr. Chairman,
give way first to Senator
Greg. From my kabayan to just raise one point.
Sige po.
Secretary Aguirre, no, Sid, I just want to add this to the conversation. No? The intent of our proposal was to ensure conviction. Yun ang intent namin sa bill, no? Doon sa wiretapping bill.
Yes, Senator.
To ensure conviction. Dahil we have been complaining na pagpasok ng ebidensya, either weak o hindi natin nahuli sa window. So, I just wanted to add that to the conversation para you, on the ground, who are better at this, no, can process this and make a technical proposal to your committee. Para we can decide kung suspicion ba talaga o probable cause. But the intent, if we project the trajectory of this, is to ensure conviction. Para wala na tayong bottleneck dun sa prosecution.
In other words, this is being made in order that this evidence, which is not allowed under Republic Act 4200, would be admissible,
airtight.
admitted in evidence.
Tuloy-tuloy po.
Opo.
Thank you, Mr. Chairman. Thank you, Senator Leila. Tapping. Dahil linagay ho namin sa bill namin, no? I'm referring to Proposed Senate Bill 21 and 48. Is it going to be mere suspicion or probable cause? Sa bill ho namin, linagay namin probable cause. Pero let me explain, give me a little time to explain. No? Mabuti ho si Senator Lacson at saka si Senator Soto. May ground time sa anti-drug operations. No? One lifetime ago, sa mga sindikato, kami naman ho, we operated under we tried to wiretap. Of course, we operated under the instructions of the Minister of National Defense. Ngayon ho, we need to strike a balance between, right. So, tinatanong ko lamang po yun because I'm looking at this from the perspective of our operators where kailangan mahuli nila yung conversation within a window. Would this determination as a basis for a court order, no? Panahon ho namin to, that's about 30, 40 years ago. We're operating under a window. Huhulihin mo talaga yung conversation in that window. Of course, iba ho ang sitwasyon, no? We are under different circumstances. So, pag hindi ka nakapasok dun sa window, wala na. Because orders, instructions from the heads of the drug syndicates would be translated into action on the ground. Sa kwan ho ito, no? When we were assigned to the Ministry of National Defense, we went against drug traffickers also. Hindi pa huuso nun yung shabu. So, heroin, cocaine. Can you imagine ho ang feeling ko no? Army officer. I did not even know what cocaine or heroin looked like. But I raised this issue because this might be material to our operators on the ground.
So, I'd like to recognize, we'll hear your comments afterwards, ano? Bigyan ko lang ng floor kay Senator Honasan. Thank you.
Thank you, Mr. Chairman. Secretary Aguirre.
Senator.
Good morning po. Please educate us on the issue I want to raise, taking off from the issue raised by our chairman. Ano ho ba ang quantum of evidence required para payagan ng korte yung